Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration.
Do you ever feel like you're spending more time on paperwork than practicing law? Many firms lose nearly half their day to outdated systems. This free guide to the best immigration software for law firms in 2025 will help you fix that. E-Immigration compares the 6 leading platforms side by side, so you'll know which software actually reduces admin work, protects client data, and helps your team work faster. Stop drowning in forms. Start practicing law. To get the guide, head on over to get.eimmigration.com/resources or save time, click on the link in the show notes.
And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Hello, everybody. Before getting to the 5 cases, I wanted to mention that longtime friend of the podcast, former immigration judge David Kelsch, recently retired as an immigration judge and now has a new venture consulting on complex immigration matters and writing appellate and trial briefs. He's got over 25 years of experience representing immigrants and 10 years in government service as an IJ and at the asylum office. Heads up as well, he's got a lot of experience with trig issues, and I'm going to be returning to that as soon as another material support of terrorism case gets published by the courts. Although I never appeared before Judge Kelsch, my interactions with him over the years has convinced me that he's precisely the type of IJ that we want on the bench, and who can provide exceptional value now that he's back in private practice. You can find him at AMDG Law LLC on LinkedIn and in other socials, or even in the show notes. By the way, AMDG is an acronym for a Jesuit phrase, which translated into English means for the great glory of God. That's the kind of person Judge Kelsch is. Hit him up if you can use his services. What do you think of these 5 cases, Judge? Starting now. Last week, we kicked it off with a non-immigration categorical approach type case, and so I thought I'd do it again. This week, United States v. Ford, aka Caveman, published by the 10th Circuit on October 28, 2025. Another criminal law originating crime of violence case. Due to the type of criminal issue at play, and for reasons that need not concern our pretty little immigration minds, the entire issue comes down to whether federal kidnapping in violation of 18 U.S.C. Section 1201A is a crime of violence as defined at 18 U.S.C. Section 16A, which of course is the exact same statute used for the immigration crime of violence definition. It is not, explains the 10th Circuit, not a crime of violence. And you will notice that I mentioned the AKA in this case title. The criminal cases often have them for reasons I don't quite understand, and I never say them, although I do suspect that some of it has to do with gang relations. But Caveman? That's good. That's good stuff. I'm saying it. Mr. Caveman is getting a lot less prison time. Left the laugh in. First, and interesting for crimmigration arguments elsewhere, the 10th Circuit explains that even though the particular sentence enhancement provision doesn't cross-reference 18 U.S.C. Section 16, Congress chose the term crime of violence, which has a specific federal definition, namely Section 16A and B. But of course, Section 16B is now unconstitutional, thank you to Maya, so it's just 16A. Important to remember when, during the categorical approach, you need to define your federal term by arguing that Congress chose to cross-reference it with another federal crime because Congress used the same term. You feel me? If it helps your argument, of course, because that's what the 10th Circuit is doing with the phrase crime of violence here, going right to the definition Congress used, even though it didn't cross-reference Section 16 in this particular statute. Now that we have our federal definition, Section 16A, we have the same categorical approach at play as used in immigration. So does federal kidnapping, quote, always require the government to prove beyond a reasonable doubt as an element of its case the use, attempted use, or threatened use of force, end quote? Because that's what the federal crime of violence definition requires. The government need not. The upshot for the government is they get to incarcerate more people for federal kidnapping, but at the price of Stephen Miller's frustration of potentially permitting more non-citizens to keep their green cards. And who wouldn't want to pay that price? Federal kidnapping applies when a person, quote, unlawfully seizes, confines, inveigles, decoys, kidnaps, abducts, or carries away and holds for ransom or reward or otherwise any person, end quote. I imagine that applies to ICE officers too. I just suppose the argument is qualified immunity. Interesting, though. Anyway, those are means of committing the crime, not separate elements that a prosecutor must show. That makes the crime indivisible, meaning the crime of violence analysis comes down to the least culpable of those conducts. That, in turn, is inveigling, which means, quote, luring or enticing or leading the person astray by false representations or promises or other deceitful means, end quote. Nothing forceful or violent about that, just criminally sneaky. Apparently, the 11th Circuit has also held this in a decision called Gillis, and the 1st Circuit in a case called Coleman, and the 4th Circuit in a case called Wills. Back to the 10th Circuit, it doesn't really matter that there is a serious criminal penalty for federal kidnapping, explains the court. Nor does it matter that this is actually kidnapping of a child in this case. The categorical approach is all-powerful. As the 10th Circuit notes in a footnote, this is all really happening here because the Supreme Court found Section 16B unconstitutional, because this crime almost surely would be a crime of violence under the then-constitutional residual clause. But the Supreme Court held what it held, and we live with the consequences, both for non-citizen good and bad. Usually bad. And that's pretty much it. Relatively short and sweet, and consequential. And that is United States v. Ford, a.k.a. Caveman. Moving on to the BIA only because I have to. We have matter of CIGM and LVSG published by the BIA. This is a decision sustaining an interlocutory appeal filed by DHS. That rare bird of a procedural tactic that I do believe has now been sustained multiple times during this, the second Trump presidency, on DHS's interlocutory appeal. The case is about the safe third country removal bar to asylum as subject to regulation at 8 C.F.R. section 1240.11h, referred to here as the ACA. According to the BIA, its interlocutory intervention is necessary because, quote, the handling of cases subject to the regulation have recently become a recurring issue, and our decision in this matter will provide guidance to immigration judges and the parties on the proper application of the regulation, end quote. Let's be honest, guys. The BIA deems interlocutory intervention during a shutdown necessary because finding as many ways to prevent non-citizens from claiming asylum in the United States has become an urgent and, dare I say, paramount issue for the BIA. This decision is certainly in line with that. The respondents appear to be a family from Guatemala. Once given the opportunity to apply for asylum in immigration court, DHS then moved to terminate their case because America has astonishingly entered an agreement with Honduras to send asylum seekers to Honduras for Honduras to consider their asylum claims. Except, of course, for the thousands of Honduran asylum seekers fleeing persecutory conditions in that country, who I'm near positive we're now trying to send to another Central American country for the same reason. Dare I say Guatemala? Beyond the scope of this decision. Seeking to avoid being sent to Honduras, the Guatemalan asylum seekers here filed a brief alleging a fear of being sent there, quote, because they are refugees fleeing from threats and violence against their family in Guatemala, end quote. They claimed it wouldn't be safe for them in Honduras either. An immigration judge agreed and denied DHS's motion. The BIA overturned that interlocutorily. By statute, America can send asylum seekers to a safe third country, quote, in which the non-citizen's life or freedom would not be threatened on account of race, religion, nationality, membership in a particular social group, or political opinion, and where the non-citizen would have access to a full and fair procedure for determining a claim or asylum or equivalent temporary protection unless the Attorney General finds that it is in the public interest for the non-citizen to receive asylum in the United States, end quote. Does all that sound like Honduras to you, based on what you know about Honduras? We're going to do a Honduran asylum case, by the way, later in this episode. Now, by Trump 1 era regulation, 8 C.F.R. section 1240.11h, asylum seekers who enter the United States on or after November 19th, 2019 are potentially subject to the safe third country bar. The regulatory exception against that applies essentially if the non-citizen establishes a withholding or Convention Against Torture claim from the third country. And astonishingly to me, explains the BIA, quote, immigration judges do not have authority to make the determination required under the statute as to whether the non-citizen would have access to a full and fair procedure in the third country because the Attorney General has expressly reserved that statutory authority, end quote. So if Attorney General Bondi says Honduras will be fair, Honduras will be fair. Similarly, quote, immigration judges lack authority to determine whether it is in the public interest for a non-citizen subject to the ACA to pursue asylum in the United States because the statute reserves to the Secretary of Homeland Security or her delegates the determination whether it is in the public interest for the non-citizen to receive asylum in the United States, end quote. So what is an IJ's role then? You tell me. Not much, it seems, as the United States entered into an applicable agreement with Honduras for these things on March 10th, 2025. God knows what America gave Honduras to accept Guatemalans. I bet it was a lot. But the IJs, of course, don't have authority to inquire into that either, so it's not part of this decision. Quote, the ACA does not apply to unaccompanied minors, nationals, or habitual residents of Honduras, or people involved in certain crimes or subject to Interpol notifications, end quote. So I imagine IJ has authority to determine that. But it would apply to the non-citizens here. How does it all work? Well, DHS provides oral or written notice of its intent to send someone to the third country, here Honduras, and then the non-citizen has a, quote, reasonable opportunity, end quote, to show that the safe third country bar does not apply, or that he or she can establish a withholding or CAT claim. Honestly, it sounds kind of like the limited rights non-citizens have when subject to reinstatement of a prior removal order, the very harsh rules that we understandably apply to non-citizens who have been removed and then who enter unlawfully. Not, of course, the case with this asylum-seeking family from Guatemala, but these are the rules that the Trump administration has created per a statute that has largely remained dormant for nearly 30 years. Also, in case you're wondering, quote, immigration judges may not require DHS to demonstrate that an ACA country of removal is willing to accept a respondent who is subject to the terms of the ACA, end quote. Like, literally can't do anything. An IJ can determine whether the ACA bar applies, but that does seem a bit pro forma. Nor does the BIA believe that adjudicating, withholding, or CAT claim from the third country should be that difficult, quote, more straightforward, end quote, than a regular CAT or withholding claim because the non-citizen has no connection to the third country of removal, which is, of course, the point. And so here we go. Without any humility, the BIA states, quote, thus, if a respondent subject to an ACA claims a fear of persecution or torture in a relevant third country, but has no substantial connection to that country, an immigration judge should typically be able to resolve the applicability of the safe third country bar without conducting a full evidentiary hearing, end quote. The BIA suggests a master calendar. So again, the asylum-seeking duo from Guatemala at issue here. Their succinct statement of fear of removal to Honduras was probably not sufficient for them to get a meaningful hearing, much less prevent their removal to Honduras, as the IJ did, explains the BIA. So the IJ aired, quote, "The generalized evidence of country conditions in Honduras submitted with the response to DHS's motion is clearly insufficient to satisfy the burden of proof," end quote. And again, it's going to be quite difficult to get specific evidence for a withholding or cat claim because by definition, these people have never been to the third country to which removal is being sought. The BIA explains further that even though the ACA agreement with Honduras was entered into well after the respondents filed their asylum applications, they're still subject to it. And that's because the regulation upon which this is all based, and which the Biden administration did not kill, is from 2019. In any event, the ACA with Honduras makes quite clear by its terms that it applies to pre-ACA peoples as well. Not a retroactivity problem because it's being applied prospectively to screw people, explains the BIA. The BIA concludes by reiterating that both it and the IJ must take Miss Bondi and Miss Nome at their word that Honduras provides, quote, "a full and fair procedure for adjudicating asylum claims, and it would not be in the public interest to allow the respondent to pursue her asylum claim in the United States," end quote. Remanded, and with quite the heavy cloud. Where are you at, Congress? This is your bipartisan asylum statute that the BIA is interpreting, after all. Where are you at? And that is a matter of CIGM and LVSG. Moving on to Chen et al. V. Rubio et al., published by the Second Circuit on October 29th, 2025. This case is mainly about the doctrine of consular nonreviewability. That pesky podcast foe. The Chen plaintiffs here are a family from China, and they are U.S. citizens. They filed I-130 petitions for their sister and mother, respectively, to come to America, petitions that were approved. But the consulates did not let those family members come to America as lawful permanent residents. Following their respective interviews, they were provided Department of State forms that stated as the basis for denial, quote, 212A6C, fraud or misrepresentation, end quote. INA 212A6CI, that is. So the Chens sued in federal court. Because of the increasingly narrow case law limiting consular processing denial lawsuits, they alleged that the consulate's denial was, quote, not facially legitimate and bona fide, end quote, and that it was, quote, issued in bad faith, end quote. Clearly trying to track Justice Kennedy's concurrence in Kerry v. Dinn, and of course Kleinden's v. Mandel from 1972. But during this case, the Supreme Court published Munoz, holding that U.S. citizens like the Chens have no constitutionally recognized interest in living with their family member in the United States. Pretty rough, given the constitutional liberty interest is kind of at the heart of any lawsuit filed by a U.S. citizen to permit their family member's entry. Gotta find some constitutional right, it would seem. So the district court dismissed, relying on Munoz. And despite so holding on Munoz, actually, quote, the district court also considered plaintiffs' allegations that the visa denials had been issued in bad faith and concluded that plaintiffs' allegations were insufficient to make their claim of bad faith plausible, end quote. So, I mean, there's that. Implicit recognition by the district court that if sufficiently shown, which is near impossible without discovery, there might be a way to file a suit like this, even without the constitutionally protected interest? I don't know. Doesn't matter, because the Second Circuit affirmed the district court on the constitutionality stuff. The doctrine of consular non-reviewability exists, after all. Now, true, quote, the Supreme Court has assumed that a narrow exception exists when the denial of a visa allegedly burdens the constitutional rights of a U.S. citizen, end quote. But also the Supreme Court, quote, has never suggested that the doctrine is subject to any exception where the visa denial does not burden the constitutional rights of a citizen, and even where it does, the citizen plaintiff cannot prevail if the government has stated a facially legitimate and good faith reason for the denial, end quote. So Munoz is a huge problem because it held that U.S. citizens don't have a constitutional interest in bringing their family members over. There, that was the wife trying to bring over her husband, which, quite frankly, is an even closer relationship than the familial one at play here. As such, explains the Second Circuit, the whole facially legitimate and bona fide stuff doesn't even apply. To throw in some Tagalog learned from my wife, that is napaka rough stuff. Taglish, really. Synthesized then by the Second Circuit, the Supreme Court, quote, has made unmistakably clear that the exception that it assumes exists permits judicial overruling of a consular decision only when the decision both burdens the constitutional rights of a citizen and lacks a legitimate and bona fide reason, end quote. As such, and like Miss Munoz herself, the Chen plaintiffs here lose from the onset. Can't even get into the reasons. I'd simply note that there has been at least one successful and very creative consular non-reviewability type win in the last year discussed on the pod, and there was also that near success from the 10th Circuit based on the Religious Freedom Restoration Act. Just noting. And that is Chen et al. V. Rubio et al. And now, a word from our sponsors.
Good morning, Law Office of Aaron Gomez. Trevor speaking. How may I help you?
Hello. I came across your info on Google. Do you by any chance handle 601 waiver cases? My deadline's coming up just like a few weeks away, and I'm having trouble to get it done. Can you help me?
I'm really sorry, ma'am. At the moment, we're at full capacity. We're not taking any new cases on right now.
No way.
That's not just a lost call, that's a lost client. And it happens every day. With Staffy outsourcing, you don't have to say no. Staffy takes care of the heavy lifting, forms, document collection, assembly, and quality checks at a flat rate of $550 per case. No contracts, no hidden fees, and your first 3 cases are free. Say yes to more clients and grow without burning out. Don't just think about keeping up, think about leading. With Staffy, elevating stress and working smarter will let you double down on building your practice. Visit www.staffy.cc or call 786-891-5619 today. That's www.stafi.cc. Or, of course, click on the link in the show notes.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Next up is Alfaro-Zelaya v. Bondi, published by the 4th Circuit on October 31st, 2025. Halloween. This decision is about proper consideration of asylum claims. Judge Wilkinson dissented. Miss Alfaro-Zelaya is from Honduras and was beaten by her uncle for years as a child, told, quote, because she was a woman, that was her job to make food for him, end quote. The grandparents eventually resolved that, but then she entered into a very abusive relationship with a man named Brian. She had a son by him, escaped, and began dating another man who eventually turned into a horrible, abusive person, too. That person, Juan Jose, had threatened Miss Alfaro-Zelaya as recently as March 2016. She moved 2 hours away to live with her mother, but began getting harassed by a man there, being quite clear that it was because she was a young woman. That man, Matute, began stalking her and even tried to kidnap her once at gunpoint. Seems like she just barely avoided a rape by him as well, and she fled the country with her daughter. Used a smuggler to do it, known as a coyote in that part of the world, because there are few other options for many classes of Latin Americans. And Miss Alfaro-Zelaya was raped by him during the journey. All the while, Matute's been looking for her, going so far as to ram his car or collide with the car being driven by Miss Alfaro-Zelaya's grandparents, cousin, and son in the pursuit of her. When she arrived, the U.S. government sought to deport Miss Alfaro-Zelaya and her minor daughter. And the IJ and the BIA ordered it. A split Fourth Circuit remanded. And do forgive me, but it's Halloween Eve and I have candy to give and a toddler hobbit to present to the world. To be fair, the IJ did make an adverse credibility finding, although even the BIA doesn't appear thrilled by that because they didn't affirm on it. So we've simply got nexus to a protected ground for asylum and withholding, and that is the asserted particular social groups of Honduran women and unmarried mothers in Honduras. Don't get me wrong, too, a win's a win, but some are better than others for non-citizens writ large. I'll take it for Miss Alfaro-Zelaya, but would have loved a particular social group ruling here. Instead, quote, leaving the merits of the BIA's nexus determination for another day, we conclude that the BIA's failure to consider country conditions evidence constitutes an abuse of discretion, end quote. The Fourth Circuit starts with Cat. The BIA denied on government acquiescence, relying, it seems, on that prior attack by Matute in the park, that near rape I mentioned, where police did stop it. But there were 2 stalking reports where police took no action, apparently, and the near abduction at gunpoint. Gotta consider all evidence and events or get remanded, explains the Fourth Circuit majority. Also, the country condition evidence shows that, quote, violence against women is rampant in Honduras, fueled in part by gaps in the criminal justice system with the highest femicide rate in the world. And yet, crimes of sexual violence are particularly unlikely to be taken seriously by the police, with an overall impunity rate of 95%, end quote. Seems like important country condition evidence to me, for you to maybe rely on your similar Honduran case. Horrifyingly, as of 2011, quote, gender-based violence was the second highest cause of death for women of reproductive age in Honduras, end quote. Apparently, the BIA didn't meaningfully talk about any of this, so it's got to go back on Cat. Next on to asylum and withholding of removal. Same problem with the ignoring of country condition evidence, I'd imagine. But to win here, Miss Alfaro-Zelaya would generally have to show error with the nexus analysis itself, right? Well, returning to Matute, the IJ and the BIA believed that he was simply, quote, infatuated with her and wanted to have a relationship with her, end quote, and that he wasn't doing these bad things to her on account of her being a Honduran woman or an unmarried mother. But as we so often discuss on the pod, it's not an either-or proposition. Mixed motive cases are alive and well, and here the BIA apparently failed to consider country condition evidence that could contextualize the reason for Matute's actions. Not to mention the other men, but apparently that line of argument was not exhausted before the Fourth Circuit. Quote, the agency's wholesale failure to discuss the evidence is itself an abuse of discretion, end quote. And there was lots of it, apparently. Arguing with Judge Wilkinson for a bit, and making quite clear that the remand was limited, the Fourth Circuit majority remanded. By the way, it called one of Judge Wilkinson's positions a, quote, parade of Sister Circuit straw men, end quote. Take that. It does roll off the tongue. No time on this Friday evening to read the dissent, I must admit, but the majority does conclude like this, quote, at the end of the day, our colleague in dissent may disagree on matters of degree, but the principle remains immutable. No means no. And unless every encounter between a man and a woman in Honduras culminates with the man forcing her into a car at gunpoint, stalking her at her workplace, and threatening to dismember her child should she refuse to have sex with him, the dreaded breach in the floodgates the dissent foresees will remain securely shut, end quote. Right on. Judge Wynn concurs and would actually reverse on nexus and outright hold that Matute targeted Miss Alfaro-Zelaya on account of her gender. As for Judge Wilkinson, and admittingly stated somewhat out of context, quote, this is all too much, and I cannot assent, end quote. Remand it is, though. And so appropriately, congratulations Edith Leonore Sangueza and Anne Elizabeth Peterson from the Center for Gender and Refugee Studies for petitioner. And that is Alfaro-Zelaya v. Bondi. Concluding with a repeat offender, Bastias v. U.S. Attorney General, published by the 11th Circuit on October 30th, 2025. This is an 86-page per curiam decision on the crime of child abuse, abandonment, or neglect. Per curiam means that no judge on the panel took authorship of the majority opinion, and they all just agree together. Kind of like judicial kumbaya, although sometimes it seems like judicial indifference. It's also like the third time that this specific case has come before the 11th Circuit. The last time was on episode 119 of this glorious show. Since then, the matter went up to the Supreme Court, which sent it back to the 11th, which here affirmed removability in only 3 pages. Just why it affirmed is the subject of 81 pages of concurrence by all 3 judges, and so quite frankly, I'm not sure what is binding. For the purpose of 11th Circuit practice, what is binding is the crime of, quote, willfully or by culpable negligence, neglect of a child without causing great bodily harm, permanent disability, or permanent disfigurement to the child, end quote, in violation of Florida Statute Section 827.032D, constitutes an INA Section 237A2EI crime of child abuse, abandonment, or neglect. As far as I can tell, that's probably the only thing binding from this decision. Why the 80-plus additional pages, then? 2 words. Loper Bright. Loaf of bread. Seems like the panel cannot agree what the 11th Circuit should do with that bad boy, and Judge Newsom flat out urges the 11th Circuit to go en banc in his concurrence. So I am loath to go all in here and will not do so. I will wait for the 11th Circuit to sort things out. But to summarize, Judge Newsom believes that at present, the 11th Circuit is bound by prior immigration decisions that had deferred to the BIA's interpretation of ambiguous INA provisions that had relied on Chevron deference. In this instance, that's Pierre v. U.S. Attorney General, published by the 11th in 2018, where the 11th Circuit deferred to the BIA's definition of a crime of child abuse to include a state law offense involving criminally negligent conduct that constitutes maltreatment but doesn't cause physical injury. Restated, and despite Loper Bright's mandate that federal courts define statutory terms without deferring to Congress, including terms in the INA, Judge Newsom doesn't believe that a panel can overturn Pierre's holding because one panel generally can't overturn another, despite Loper Bright. Even if all Pierre was doing was deferring to the BIA. Makes no sense to me or Judge Bumate in the Ninth Circuit, I know, and I don't think Judge Newsom is even fully convinced, but the Supreme Court used a weird sentence in Loper Bright about stare decisis, and so here we are. For his part, Judge Marcus doesn't believe the panel bound by Pierre because Judge Marcus reads the Pierre holding narrower than does Judge Newsom. But Judge Marcus does still believe that Mr. Bastias is removable and that all of this is the best reading of the statute. Then we have Southern District of Florida Judge Middlebrooks, sitting by designation. He too, of course, votes to affirm removal, but on the important issue of Loper Bright and the prior precedent rule, he defers to his 11th Circuit panel colleagues. He does state, however, that, quote, Chevron has been displaced, casting doubt on previous statutory interpretation decisions resting on Chevron deference, end quote. So again, what's the takeaway? Well, the Florida offense is a crime of child abuse, abandonment, or neglect for now. Mr. Bastias is removable for now, unless the 11th Circuit goes en banc. And perhaps most importantly, if you have a panel with Judge Newsom or Marcus, or a district court action before Judge Middlebrooks, and the applicability of Loper Bright is important, read this decision to ascertain their opinion on the matter. And that is Bastias v. U.S. Attorney General.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.